I'm Nikki Jovicic from LookUpStrata. I'm also the Managing Director of Tower Body Corporate, and I'll be your host for today's free Queensland session. If you're part of a mixed use or layered development, chances are your scheme is governed by a Building Management Statement or BMS. These documents underpin many of Queensland's more complex developments, regulating how commercial, residential and retail components share and manage aspects like driveways, car parks, insurance and maintenance. Despite their importance, BMS documents are often misunderstood. They can be technical, outdated or simply unfamiliar to committees and managers who weren't involved in their original setup. We're joined today by Frank Higginson and Dylan Carrier-Hubbard from Redchip Strata Law. Frank and Dylan will walk us through what a BMS is, how it operates, and what recent legislative changes under the Property Law Act mean for both new and existing BMS arrangements. They'll unpack common problems in layered schemes and mixed-use developments, such as unclear cost sharing, access disputes and government imbalances, and help us understand the legal boundaries of the BMS framework. We'll also explore how strata managers fit into the BMS picture and which rules take precedent when BMS terms conflict with your body corporate bylaws. Now, we take our transparency responsibilities seriously here at LookUpStrata, so I will mention again that in addition to owning LookUpStrata, I own Tower Body Corporate on the Gold Coast and previously Hines Legal, but now Redchip Strata Law is a long-time sponsor of LookUpStrata. As this is a Queensland webinar, any reference today will be based on Queensland legislation. And as always, the information shared is general in nature. And if you're facing a specific issue with your BMS or development, we do recommend seeking personalised advice from a qualified professional. Now, here's a little more about today's presenters. Frank Higginson is a director at Redchip Strata Law and one of Queensland's most experienced body corporate lawyers. Frank has worked across thousands of schemes and regularly advises on BMS complexities, layered developments and mixed-use disputes. And Dylan Carrier-Hubbard is a senior associate at Redchip Strata Law with a strong background in litigation, dispute resolution and regulatory matters. He regularly advises on complex strata issues, including BMS disputes and layered scheme arrangements. Welcome, Frank and Dylan. Great to have you here.
Great to be here, Nikki.
Thank you.
Hines has sort of departed the corporate scene and Redchip is now it. Dylan is literally sitting 3 meters away from me over there. We do quite a bit of work together on these type of things. And when Nikki you haven't done a seminar for ages, Frank, what do you want to do? I said, what about this? It's great. I was like, oh, that was pretty easy, but here we are. So for me today, what we're talking about, some BMS basics, because these are, I suppose, difficult documents to understand, and they're off the reservation when it comes to strata law, but body corporates are quite often caught up in them. Talk about some of the stuff that we see more regularly than not, and then the sleeper. And to the best of my knowledge, this will be all new and exciting for people today, because I don't think anyone's really gone live with what has changed in the Property Law Act with respect to BMSs yet. Some basics to start with though, and the first thing is that they're not body corporate documents. When you're in a body corporate and you're governed by a BMS, the default position, as you would think, is to go to the BCCM Act or the modules or whatever it might be and find out where all these things are created there. And that is not where they actually start from. They're actually a titling document, and that comes from the Land Title Act, which creates the titling system in Queensland. There are sort of similar type structures in other states, but this is, as Nikki said, a very Queensland specific one. I do not know how the other states operate. We certainly know how Queensland operates, and that's what these BMSs are for. So they're a titling document under the Land Title Act, and one of the key things is that one of the lots needs to be what's called a volumetric lot. So in Queensland, we have now standard format plan lots. So if you've got, back one step, if you own your house, 400 square meters, you have title of that. Big black line around the boundary of it, it's yours. Inside a body corporate, you've got standard format lots, which is the same sort of thing which you see in townhouses more often than not, where you have a boundary around your lot and you might have a villa constructed on it, and that is then yours. So if it's not subject to other parts of strata law in terms of shared roofs and that sort of stuff, the roof's your problem, the external wall's your problem, and it's your land. Then there's a building format lot, which is really high rises, as much as low rises can also be building format lots, to add some confusion. And that's effectively where you own to the midpoint of the wall. So if you're up on level 30 of a building midpoint, 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 midpoint. That's the title to your lot in there. And a volumetric lot is something that is effectively, purely and utterly just a total piece of airspace. Because in that building format lot, you've still got an interest in the common property, which is down on the ground level, which is that building was created. Volumetric lot is this cube, for want of a better phrase, from level 1 through to level 30, and that is then subdivided. So to have a BMS, you need to have one of those to start with. And that is where the BMS is created by virtue of that lot then having a relationship with other lots in the same type of building structure. So it sounds complicated, and in a sense it relatively is, but we've also now moved from what used to be, a straight up high rise to much more mixed use things and things like that. And if you want, I suppose in Queensland, the first example of a BMS, it's Alunga and Bella in Hanlon Street, Surfers Paradise, beside the Paradise Centre. They actually had to create separate legislation, HSP nominees, which was Kornhauser, Enabling Act. And what they've got there is effectively a version of a BMS, Upper Plan 1 and Lower Plan 1. Upper Plan 1 is the building, Lower Plan 1 is the car park underneath it. So that's a really unique thing, but we've got a bit more sophisticated since then. The reason that a body corporate is almost always involved in a BMS is because that volumetric lot is going to be subdivided into strata lots and then forms part of that overall building. So you can have retail, commercial, whatever it might be, but the residential bit is the bit that the developers want to make their money on and sell. There might be other parts to it, but the body corporate is then one party to that overall document. And I'll talk a bit more about that with a picture in a minute. And the easiest way to tell whether you're subject to a BMS is the title, or the document will be registered against the title to your lot. When you look at your title search, you'll have the rights and interests reserved to the Crown. The second thing may well be the mortgage to your mortgagee. If you don't have a mortgage, then good on you. And if there is a BMS that your lot is subject to, it will be registered against your specific title. And you can always get a copy of that document. If there's a BMS registered there, you are subject to it, and your body corporate is going to be subject to it. The next thing to probably understand is we've got BMS, which is Building Management Statement. Under that document, there is a Building Management Group, which is effectively the committee for that BMS. So yes, this is where another layer of complication comes into existence with these structures. If we've got our volumetric lot, which is our building here, that is a normal body corporate that has 100 lots. It's got a committee. It's subject to the BCCM Act. It's subject to all the things that I suppose, Nikki, we bang on about endlessly with all day, every day. And on top of that, then, that body corporate will be a member, more than likely, of the building management group with the other representatives of the other lots that are part of that BMS. So BMG is effectively the committee for the building management statement. So, yep, that's another layer. And this is probably the big one for me. A lot of people don't necessarily understand. It's not a voluntary participation piece, a BMS. It's registered against your title. The body corporate is a party to it. And sometimes it's hard to tell when these documents are first registered. So say we've got a residential piece, a commercial piece, and a retail piece. When that BMS is registered against that title, it goes in before the body corporates existed. So what you might have is lot 1, lot 2, and lot 3 on SP, whatever it is. That lot 1 subsequently becomes the body corporate. So the body corporate is a party to it as much as it won't look like the same survey plan number when you read it, but when you follow it through, it is. And that BMS is a contract, same as easements. So an easement registered over your title that gives people the right to pass and repass for particular purposes, that's there and it stays there, and it does not change unless everyone agrees to it. A BMS is the identical thing. So it's locked and loaded. Body corporate can't turn around in 6 months' time and say, actually, I don't like that bit. I want to get rid of this bit. We want to change our proportions here and all that sort of stuff. It does not work that way. Same as if, I sign a contract to buy Dylan's house for 500 grand. I don't turn around halfway through and say, actually, mate, you know what? Now it's 450. That's the deal. And it's registered on title, and that's the way they're locked and loaded. So they're some basics that I think people sometimes conceptually need to understand. Interestingly enough, in our strata legislation, we've actually got pictures. So if you go to the back end of the BCCM Act, there's a bunch of pictures about types of different strata arrangements. A building management statement does not come into existence in what's known as a layered arrangement of bodies corporate. A layered arrangement is one where you've got a head body corporate up here, and then you've got individual subsidiary members of that body corporate. So the head body corporate up here may have only as part of it the pool, the gym, and some driveways. These other bodies corporate are lot owners in that head body corporate, contribute towards its costs, the insurance, the maintenance, and all that sort of stuff. And then down there, they've all got their own bodies corporate. So a bodies corporate can be a member of another body corporate. That's what's known as a layered arrangement, and that's not what a BMS is. Because these ones, this is all purely and utterly caught by the BCCM Act and the related modules. Lot entitlements, bylaws, all of the stuff that we're actually familiar with. What a BMS actually is this. The example I always use, and apologies if anyone from Victoria Plaza is on this call. So when you go to Victoria Plaza down in Broadbeach Mall, what you've got down here is a whole bunch of shops, restaurants, whatever it might be. You've then got office space, and then you've got a residential building. What you have in that building, and this is old school before BMSs existed, you have three, in a sense, completely different uses, all tucked into the one body corporate. So what that creates over time, inevitably, is going to be conflict, misunderstanding, and potentially disputes. Not that BMSs don't allow those things to happen as well. But the issues that come up, for example, is that, let's say, insurance for retail shops becomes harder. The difficulty with three different types of uses in that one body corporate is that the contribution schedule lot entitlements are going to dictate the proportionate share of everyone's expenses. In theory, there was some rationale put together to allow for bits and pieces to change over time, but they're a very blunt tool. If we started from an equality principle where everyone's got an entitlement of 1, and everyone's sharing 1/100th of the expenses, and the retail expenses in effect go through the roof, that is sheeted home to the other users by virtue of their lot entitlements. There's no flexibility there with that at all. Same as from an office perspective, their costs might be going down because they're a safe operator. Then you look at the maintenance expenses. It's pretty safe to say that the people in the retail and the office won't be using the pool that might be there for the body corporate. So that's really a residential use. It's trying to unscramble an egg in one sense, and particularly back when there was no, and still there's weasel words for want of a better phrase in terms of how you come up with lot entitlements now. But up till 2011, you could seek to adjust lot entitlements. That's not the case anymore. There are deciding principles that need to be explained in terms of whether lot entitlements have been created on a relativity basis or an equality basis or whatever it might be. But that still doesn't help our people in Victoria Square because that was created before any of that stuff existed. So they've all got a number. That number's fixed, end of story. That's their proportionate share of the operating cost for that building. What BMSs do is something different. So with Victoria Square, for example, we've got a parcel of land down underneath that. Maybe it's 1,000 square metres. We go down into the basement and then we go up with our respective uses. So in a BMS situation, the basement area and this foyer area and the grounds and gardens outside is what's known as a shared area. So the way a BMS works is that that area will be attached to and belong to one of these individual parcels. So there's our residential bit, there's our office bit, there's our retail bit. So say for argument's sake, it belongs to the retail component. What a BMS then allows to happen or creates the rights for is that the retail people give the office people and the residential people or this lot and this lot, probably the best way to put it, the right to use those areas in exchange for payment of operating costs and whatever the other rules might be. And I'll talk a bit more about those in a minute. But fundamentally, there's a block of dirt, it's owned by someone, and effectively it creates rights of use and contribution from the other people or the other lots that are party to that BMS. So if this was our BMS, we'd have lots 1, 2, 3, and a perfect BMS for me is one that A, deals with all the statutory stuff, but B, in a perfect world, has at the back end of it a schedule. These are the shared areas. So for example, inside, if this is our residential lot, there's areas there that aren't used by these other lots. So that's for this body corporate to deal with as it sees fit. It might have its own private pool, for example, on the roof. These other lots aren't using it. That then belongs to that body corporate. It's 100% responsible for all of the decisions and costs relating to it. But we're going to have car parks, we're going to have gardens and grounds outside, we're going to have foyers, we're absolutely going to have a lift, we're going to have fire exits. All of those things are property that will be shared by all of these people, and the BMS regulates how that happens. And that for me is the essence of a BMS. Inside these bodies corporate, if they are subdivided, they make their own rules in relation to their own common property. But the sharing of the overall facility here is what that BMS regulates, and those shared areas. So when you come to a statutory perspective, under the Land Title Act, a mentioned volumetric lot, a BMS must address each of these issues. Supply of services, electricity, water, gas, whatever it might be, rights of access, so that's our car parks, foyers, lifts, whatever it might be, rights of support and shelter. So we're not going to allow things down here to fail that would then mean somewhere upstairs fails as well. And I suppose for the people on the roof, the roof needs to be maintained so water doesn't leak down through everyone else. So it's fairly fundamental. And one of the big ones is insurance, because even though they're three separate, we go back to that slide before, they're three separate lots, it doesn't make much sense if they're insured with three different insurers. Because the first thing that happens if there's an issue is the fingers start pointing and no one accepts responsibility. So inevitably what you'll find is that whole structure will be insured with the one insurer, and then the costs will be apportioned differently between them. So that's what a BMS must have. Then a BMS may, and most do have these things. So establishment, operation, and management group. So in a body corporate context, the modules are pretty prescriptive about how committees are elected, how many members there must be, what the roles must be, powers of delegation, all that sort of stuff. Under a BMS, because it's a separate document, there's no standard plan, there's no standard type of them. Everyone can make up their own rules, as much as you do see some more similar provisions than others. So setting up the building management group and voting rights in relation to it are purely a structure of what's in that document. Imposition and recovery of levies. A BMS allows for much more flexibility in relation to how things are charged. So rather than just 1/100th, which might be your contribution schedule lot entitlement, you can have 40% for this cost, 20% for that cost, 100% of this cost, 95% for that, user pays for this. And it's a matter of making sure that that's all structured right in the document itself. Property maintenance, dispute resolution, there always will be a dispute resolution clause in these documents. So before you want to punch on in a court or another place of appropriate jurisdiction, you've got to try to resolve it internally. From a BCCM Act perspective, that's not worth the paper it's written on, because the way our system works is that the Commissioner's Office has primary jurisdiction for disputes. Complex disputes go to QCAT, and to the extent that any type of document seeks to oust that jurisdiction, it's invalid. So, there's another key difference. So on and so forth. So those things may be included, and you usually find that sort of stuff in there. So common issues. Here's some of the things. No one document is the same as the next. That is absolutely the case. And they are relatively complicated to read. So I suppose if you stick a set of bylaws in front of me or a management rights agreement, it's probably safe to say I've seen all of it somewhere before, sometimes ridiculously on repeat. These things are not that. There are no shortcuts. And so it's really a sort of almost about as legal as we're going to get for lawyers in the strata space. And I will say it's not strata, but all of the work that we've got in relation to these issues come from strata type clients, because they've got a BMS and what do we do with this? What does this mean? How does this work? What should we do? So on and so forth. So there is no shortcut, but to reading it and actually understanding it. I suppose Redchip does a bit of development work, but certainly over the years I have done development work, but have not done it for a long time. It's very easy for me to sit here and say that documents aren't necessarily accurate, but by the same token, it's a lot harder to draft a BMS for a scheme that is not operating and is simply sitting there as a block of dirt and really is a dream by the developer who's going to be selling it off the plan over the next couple of years. That is a difficult process, because what you're trying to do is to figure out how this thing is going to work before it's built. Certainly much easier for us as lawyers, myself and Dylan, to come in afterwards and start pointing holes in things that weren't considered, because it's a bloody hard thing to do, to take into account all of the moving parts for what can be some particularly complicated structures. So just worth remembering that before you say, why did this happen? It's because it's really hard. and this is some of the stuff that does happen, there is an incredible amount of flexibility in terms of how you can cost share under a BMS. Probably one of the best examples. One, we had electricity when electricity is not getting any cheaper, but it used to be a hell of a lot cheaper 10 years ago. We had one that by agreement, we went through and literally counted the electrical power points that were accessible to people and shared them out that way. So electricity got divvied up to that level of detail. And then, of course, you build in a mechanism to say you're not going to put in any more sockets without approval. So you can get down to that level of detail. So you can move towards a user pays thing, but then measuring that becomes harder, unless you're on meters for electricity. If you're talking about use of a pool or something like that, like how do you actually do that? So again, it's as much as you can be incredibly flexible. Sometimes I think it's easier to drill down a bit, but not be too precise about it, because precision in some of these things, as things change over time, is hard. But certainly you've got way more flexibility than you do with a lot of entitlements under a body corporate. And the last one is really voting rights. So again, we see from if you're body corporate perspective, committee members have one vote, lot owners have one vote. There's mechanisms there under BCCM legislation to call for votes on a poll, which then comes back to entitlements. We go to special resolutions, and we've got entitlements, no more than 25% of entitlements against. So there's some very structured rules that have not changed since BCCM Act was introduced in 1997. Back to a BMS, because it is a feature basically of the document which creates it, the voting rights in a BMS can be whatever they are that is drafted. So you might have the position where, and we'll bash the developers, why not? Hope there's not too many on the call, the webinar. Developers keeping a retail lot on the ground floor. They've got 250 residential lots above them. From a BMS perspective, what they do in the BMS is retain a controlling or casting vote to the extent that they're equal on anything. So we've got one vote each, but if we're equal, then I decide. You can do that under a BMS, and that's the document that's drafted. So then we're back to, does disclosure solve that and all that sort of thing? But leaving that aside, that's the flexibility that you can have in these things. So, and it can be the more lots you get. So, we've got clients for a body corporate that are parties with 6 other individual lots. So they're not stratas, they're volumetric lots in themselves for different uses. So how are those decided, and where are the entitlements to vote, and is there casting votes and all that sort of stuff? That is in a sense a difficult thing to draft, to try to do it equitably. And of course, when it's put together off the plan, this is what the developer wants, that's what the developer gets. Is that necessarily fair? Who knows? But that's what the flexibility in BMS allows you to do. Volunteerism as a whole, and that's across the board. Like I do golf stuff. Committees are all volunteers. People on BMGs are all going to be volunteers. It's all well and good that you might be sitting here today understanding what it is that we're talking about, knowing that you're going to have to go and look at your document and try to figure out what it actually looks like and all that sort of stuff. The downside is that is in 5 years' time, you're probably not there and someone else is going through the exact same process that you're going through right now. So what we have done for some clients is, call it the BMS Bible, is we do a document that, for want of a better phrase, dumbs it down, simplifies the explanation of it, that can go as part of the body corporate records, so that when someone picks it up in 5 years' time and says, what the hell is this? There it is, because that's not going to change. That document is locked and loaded. It's going to stay the same. If you're not sure, we can do that, and that just helps. And obviously, there's some very complicated structures out there. This was a relatively vanilla one. There are more difficult ones, but again, they're the ones that it's just, you append the document, but here's how it works. Now, this is one that'll scare some of the body corporate managers that might be watching, and maybe some of the BMG members that are watching. For me, it is a separate body corporate in effect. You've got a BMG, you've got a BMS, it should have its own bank accounts, it should have its own books and records. In a sense, even it should have its own body corporate manager who understands the way these things work. How a lot of them are done, I absolutely get it in terms of we're trying to make this simpler, we're trying to make things more cost effective for people. They'll be run through a body corporate. So again, you come back to that example before, we've got 200 residential lots, 1 retail lot downstairs, it's in a BMS. What will happen a lot of times is that the body corporate might say, don't set it up separately. What we'll do is we'll just invoice the retail lot. We'll run all the expenses through the residential body corporate, invoice them as needed. They tip it back in, all that sort of stuff. So for me, functionally, I suppose that might work for a period, but it's fraught with danger in a couple of senses. One is that you're using the body corporate bank account for something that's not body corporate monies. So their retail lot monies would inevitably be used for that purpose. You might as well use it to start paying my household expenses. The second thing is, and Dylan, I'll loop you in here, what happens if the retail lot goes insolvent owing money?
Well, you're an unsecured creditor, so you wear it, which obviously is not the greatest position. Obviously, generally pretty hard to swallow as well, but that's the nutshell. You've borne it. You shouldn't have borne it. You've got no securities or leverage. You've got no rights that sort of go much further than Joe bled in the road that they owed money to under a credit agreement, if it's retail. So you sit in line and get 0 cents in the dollar.
Yep. And everyone says, how's that happen? Well, it happened in the GFC a lot. We had one down the Gold Coast, whole bunch of retail tenancies underneath a residential building. Residential's running the body corporate. Residential's paying all the electricity. Developer fell over owing 150 grand. So the residential body corporate effectively turned into the bank. So the chairperson of that one is still actually a client. But I remember the panic phone call. What do we do? I said, well, mate, you're owed money and you've got someone that's not going to pay it to you. So we end up figuring it out, but it was an untidy place to be for a period of time. So I get that people will want to do that, but that is not functionally right. And so I think from a body corporate manager's perspective, if you're doing that for your body's corporates, you need to make sure that they are aware of the risks they are running in the sense of these can be these problems. No one rings Dylan or myself and said, just let you know, guys, everything's going great. They're ringing us because they got problems. Something's gone wrong. And the things that go wrong are the stuff that we're talking about today. So there may be hundreds of BMSs out there operating that way with no difficulties whatsoever. But when you're on the one where things turn to custard, that's where it gets untidy. So it's much easier to follow the process, run it as a separate body corporate. There's the BMS budget. There's the contributions that are required. There's the bank accounts that they're required to be paid into, and it gets paid into that and paid out of that. Because then if you have one of the people not doing what is the right thing, and it won't be the residential body corporate because they won't be able to go insolvent, you are in a position to be able to do something about it far more immediately than rack up 6 months worth of expenses that might not get paid. Now, coming towards the pointy end, and this is the exciting bit that I was talking about before for everyone. How do you change these things? How do you vary them? By agreement. So that is everyone agreeing, and from a body corporate perspective, I think the answer is ordinary resolution at general meeting. For any other lots, it's just obviously them agreeing to it. But as it was with lot entitlements before 2011, why would people agree to do something that is potentially to their detriment? Now, you might have a completely commercially pragmatic and happy arrangement with everyone else. But the reality is if there's a BMS that is going to cost 100 grand a year to run, if one party's contribution reduces, the other party's contributions have to go up. And if the only way it can change is people voting in favour of it or agreeing to it, they're agreeing to pay more. So that is, call me naive, unlikely to happen. Because ultimately, as you go back to wherever it might be, Paul Keating's the one who always used, if there's a horse in the race called self-interest, back it every time because at least you know it's trying. And so why are people going to volunteer to pay more money? So the difficulty that we've had from a BMS perspective is that these things have been set in stone, incapable of being changed by agreement until now. We got a new Property Law Act in Queensland, dated 2023, commenced 1st of August just gone. And really interestingly, this is a section in it now. So there is a specific provision that allows Supreme Court to modify or extinguish easements or covenants under a BMS if it's just and equitable in the circumstances. Now, this is more than anything else where my friend Dylan can chat about what just and equitable means, because that is the magic phrase, isn't it, mate?
It is. And it's not a new phrase. So it's a new phrase for this sort of area of law, but it's used in just about every area that you'll find yourself in a court for. So that's Corporations Act, family law. any area that has an ability to have a certain situation that'll fall based on a case-by-case basis. So in the corporations realm, if you want to one up a company, there is a provision that says you can do it on just and equitable grounds. It's not defined. It's designed to allow the court to be fluid, but it's also designed to safeguard, so not every Tom, Dick, and Harry just goes in and tries to wind a company up. So in this perspective, accepting that it's fresh off the press, it's as of August this year. It's designed to give a mechanism, really a tool, to allow parties to sort of navigate through this in certain circumstances. And I'll go through a few examples that we've seen and how that should apply. It's super important to realize that this is not, oh, I'm not happy with this, we'll just go off to the court and resolve it. These things have to be real and proper. These things will, if they're done properly, generally require experts and third-party involvement, because effectively, whilst just and equitable in the circumstances, and then you follow that up with, and is reasonably necessary in the circumstance, you follow the sort of point 3 afterwards under sub C. It's really designed to say, if you want to change, you can now do it, but you must convince the court that it is proper. How do you convince that? You need to explain and establish what your problem is, but also why what you propose to do. So it's not simply enough to go in there and say, this isn't fair. You must also go in there and say, this is what the proposal is to make this just and equitable. And there's going to be, again, no quick fix. There's no cookie cutter approach. And in fact, one of the biggest pitfalls that I see, not just sort of from strata land perspective, but just clients in general when they come to me with problems, is that if you're in this area, it is sometimes fairly easy to get complacent. If you're a manager and you're running separate buildings, you might have had the same problem in one building and you might have got the best advice on the planet and that fixed your problem. But there's real danger in saying, well, that's what we had here. We've got exactly the same circumstances here. We can just apply that here. Not the case. Because anything such as, you'll have different lots, of course, but even your surroundings, a lot on beachside is going to have different problems and requirements to a lot in the middle of the CBD. It's one of those things where you have to tailor it the whole time. And so just and equitable is a litigator's favorite phrase, really. It allows us to storytell. It allows us to really get into areas where otherwise we might not be able to sort of have a look into it. But it's designed to help people that otherwise don't have any ability. Now, sort of as Frank touched on before, yes, you can all agree to amend, but each action has a consequence. So if you're taking from one to give to the other, the person you're taking from is going to say, well, I don't agree, and you're at a stalemate. So in terms of where this would be sort of a great sort of mechanism and a great way to navigate this otherwise pretty complicated and complex, sometimes arbitrary area, is where you have these mixed use complexes. You've got your residential, you've got your commercials, you've got your retails. And like Frank touched on before, you've got the developer potentially or just the retail, and they've got the golden vote. Whatever they want to do, that's how it's going to play. So you've got choice, but not really. You won't necessarily need a stack of evidence to run a Section 181 application in that sense. The document itself is largely the evidence. You're going in there and saying, look, you're on there's 100 lots here, and 90 of them are resi. You've got 9 that are commercial, and you've got 1 retail, and he dictates terms to everyone. It has to be changed. That's a pretty simple, pretty blatant type of example. They can get a lot more complicated, not necessarily through intention of a certain party, but just time. These documents, you're crystal ball gazing. You're doing a document and trying to assume what it's going to encompass. Some of these lots will have 2, 3, 4 stages to them. And it might very well work with the first few stages. But when the whole thing's completed and it's actually running and it's functional, suddenly it's disproportionate. Getting that advice early is probably paramount key, because again, you don't know what you don't know. The worst things you can do is ignore it. The next best worst thing you can do is try and contract out of it. So do a different agreement, because that's not going to invalidate this agreement. This is a contract, it's binding. Our breach of that contract it can be enforced. Having a separate agreement is only going to cause further legal consequences. It doesn't null the BMS that you're trying to avoid a part on. And just guesstimating, probably the biggest problem. Oh, we thought it was this, or this is the easiest way to do it, is arguably one of the biggest pitfalls you can fall into. Because it's all good while everyone's happy with how it's playing out. Not so much when someone suddenly throws their toys out of the cot, or you've got, as is commonplace, people coming and going. The original sort of body of people that might have been best friends retire, die, they sell, and a new group come in and they go, well, that might have been great because you were good friends. I'm not your friend though. I don't want to pay extra. And you find yourself in this dispute. And of course, everyone pulls out their documents then and says, well, what are our rights? And the solicitor sits there and they go, well, you haven't done that. You haven't done that. You haven't done that. You've sort of done that one. So you've been in breach for the last 10 years. A shock, a complaint. Well, no one's ever complained about it, but it doesn't need to be complained about. So in terms of how does that affect you in terms of sort of section 181, it's a mechanism. It's not a mechanism to be abused. And it's a mechanism that if you want to use, you need to get that legal advice. You need to get those practicalities. If you're looking at, is it fair in terms of contributions for amenities? It's a pool, only one area uses the pool. You're probably going to have to get some reports about how all those usages are being sustained and being accrued. It's not enough to say there's a pool there, Your Honour, so clearly they should pay more. The court and the judge is going to want to know, well, that's all great, but where's your proof? Okay, so you say that it's obnoxiously exorbitant, you have no benefit from it, and that you're all paying thirds. I can see you're paying thirds because you've given me the agreement, but where's your proof to say that it's actually fair that the residential lot should pay 70% of it? It's not going to be enough to run the common sense approach. It's going to be the case that you're going to have to prepare for this as if you prepare any litigious matter, because it's a breach of contract effectively. You're trying to amend, or you're trying to terminate a contract. And the court is not going to do that because you're bound by what you signed. That is the start point, it's the default. Until you convince a court or a judge otherwise, that is what they're going to rely on. They're not going to affect people's rights just because you say it's not fair. And numbers aren't necessarily going to be sufficient for that. You're going to actually have to go through the process. You have to hold the judge's hand through it and say, this is our concern, Your Honour. This is what we want, Your Honour. Let me walk you through why you should follow us and why you should agree with what we want to do. And I guess with any and all new legislation, no one wants to be the first loser. So it's going to take some time for this to filter through. But if we apply the same principles for the just and equitable circumstances that we do for every other area where it's applicable, the test doesn't change. What are the circumstances in this case? What are the issues in this case? What is the evidence and proof for this case? And what is your proposal, which is arguably the most important step. You can convince the court all the way through and they agree. I agree that you've got standing. I agree that you've been wronged. What do you want? You need to be able to answer that question. Or they're going to say, look, we feel for you, but we're not going to make the rules up. Tell us what you want. So there's a bit of thought that goes through it. But the first point of call, and ultimately the only real way to protect yourself, is if you've got a question or it doesn't feel right, doesn't smell right, or it simply might be the case we've just dusted dust off our BMS. It's 10 years old. It's 5 years old, or no one knew it existed. No one's been following it. That's what a solicitor's for. You're not expected. You're expected to know your documents, but you're not expected to always necessarily know how they operate. And if they're vague or they're general, then the advice is sort of the only way to navigate through it. But in terms of, is it a great mechanism for you to use? Absolutely. But used in the appropriate course. You should not be taking the mindset that this is a great way to just reinvent the wheel. This is meant to largely be for processes and systems where it's not working, everyone's at war with each other, no one can agree. go off to court and run the process. Also, you're dealing with the Property Law Act. So in terms of courts, you're not in a small court for that. Like Supreme Court, generally where you find yourself, they're not cheap to run. So it's not something you should do willy-nilly. But at the same time, if it's not working, and if you did some quick maths and based on the disproportionate way it's all working, you're actually hemorrhaging 200,000, 300,000 a year, it might actually be commercial. Yeah, you spend some serious money fixing it, but it pays for itself in the first 1, 2, 3 years. You get that peace of mind, you get that clarity, because at the end of the day, you've all got to live together as well. That's one thing that some people forget practically is this is not, you run your day in court and then you go your separate ways. Like you're ultimately going back to the same place. There's obviously complexities. People don't forget things. No one forgets the loss. And if they can get you on the next one and chip you on it, they probably will. In terms of what I'd like to see in terms of how this is to be applied, the same pitfalls remain regardless. The same concerns and issues that Frank touched on before are always going to remain the same. But the remedies largely remain the same as well. Get the advice, understand your document, don't just apply it willy-nilly, and don't shortcut it. Or if you're going to shortcut it, again, if you're in that manager role, informed decisions aren't necessarily always the best decisions. But if it's an informed decision, that is your obligation. You're engaged for a certain purpose to manage and to assist. Ultimately, generally volunteers and retirees. That doesn't mean they're always going to make the right decision, but you've got to give it to them. So if they want to run it through one account, they want to guess it, they want to do it this way because it's easier, or it's not, it's too hard to figure out. They don't want to pay for the legal advice. That's their choice. But simply trying to apply something that is just not generalist in nature and isn't the norm for the rest of the modules and the other obligations that apply here is just fraught with risk. And it's ultimately leads to calling me and me sort of saying, you've got problems. But it's a good thing. Like it's well needed.
Oh, it's a window now, isn't it? Because there wasn't the ability to do anything about it before, and now there is. And I think probably looking at that subsection 1, because all persons required for amendment cannot be obtained, that's really in effect a version of the self-resolution component from a BCCM perspective. You've got to have asked the question. You've got to have tried to get it resolved. You can't get it resolved. Here we are. So
Absolutely.
To me, yeah, it's a bit of a sort of, want a bit of phrase, Pandora's box. So that, I think, is the single biggest change for Strata out of the Property Law Act, leaving aside the disclosure provisions, which are way more intense than what they were. Now, how do you want to do questions?
We might start with how much does the BMS Bible that you mentioned cost, Frank?
Couple of grand at most, usually. Subject to, I mean, if you're down at Portside Wharf, for example, where there's BMSs on top of BMSs on top of BMSs, it'll be a little bit more. But if you're relatively vanilla, it's not, I suppose from our end, it's not difficult in a sense to put together. It's not sheep stations.
Okay, we'll give you a call.
Absolutely.
Yeah, that's probably the best thing to do. If they are to be managed as separate entities and act as partnerships, shouldn't the insurance be quoted on separately as well?
Well, I think you're not going to quote insurance. If you've got those 3 separate structures, you're not going to have a separate quote for the body corporate, for residential, commercial, and retail. You'll have one quote for the whole lot. But if you go and shop the insurance to different insurers, then absolutely. But it should be for the entire structure.
Our residential scheme is part of a mixed-use complex with a BMS, but no one on the committee fully understands the BMS terms or how they affect our obligations. Is the body corporate legally required to comply with the BMS even if the committee never formally agreed to it? And how can we ensure we're not inadvertently breaching it?
Bible. Well, I mean, I suppose even though you didn't agree to it, you have bought subject to it, would be one way to put it. So it's on your title, so you are bound by it, end of story. Starting point would be to understand it and then make sure that you're complying with what you should be complying with straight up. And that's, again, the separate accounts, have we got the heads of charge right? Do we actually know what the shared areas are? Who's maintaining these? And there might be good news or bad news in that, in the sense that you might be overpaying or underpaying, but ultimately, that's the document, that's the contract, that's what you're bound by. And unfortunately, I suppose, like it or not. So you've got to start with understanding what it is and go from there.
We've had ongoing issues with access and parking in a shared driveway that falls under the BMS. The commercial lot owner often block the entrance, but our strata manager says it's not our jurisdiction to enforce anything. Who's responsible for managing these kinds of disputes under a BMS, and what recourse does the body corporate have if the BMS isn't being followed?
The body corporate does have rights to enforce what its position is under a BMS, because I'm assuming, again, so it starts with what the document is. If there's car parking access, that invariably is going to be a shared area. There should be rights or people's rights and obligations with respect to the use of those shared areas should be in the BMS. You'd say not blocking other people from accessing would be one of those rights or obligations. So the starting point would be letting the people know, as you would be in a normal body corporate, guys, these are the rules. You're not following the rules. Can you please start following the rules and go from there? And there's also, in most BMSs, there'll be a dispute resolution provision. So to the extent that that's not followed, then you need to trigger that and start hopping into that process. But absolutely, it's not a bylaw enforcement piece, because it's probably it might not actually be your area. Might belong to the other lot, but they've given you the right to use it, and they've given you the right to use it on these terms. And if they're not complying with those, then that is a breach of contract in an absence of anything else.
Are there any legal remedies available to a body corporate if one party to the BMS consistently fails to pay their share of shared costs, such as insurance or maintenance of shared areas? How enforceable are these cost-sharing obligations under the new Property Law Act changes? And it made me think of things like you mentioned during the presentation, ongoing costs like electricity, but I was thinking more of when there's a one-off cost or something that doesn't happen regularly, like painting of a building and what the access looks like, and also who project managed a big project like that.
Yep, no, that's all. And that's interesting, sort of the CapEx components of maintenance like that, and which parts of the lots are we actually painting, because we're separate lots. We've got our residential up here and our commercial here, and the presentation of the building as a whole. BCCM, we've got statutory obligations to keep common property in good repair and condition. What's the BMS actually say? So yeah, but back to, I suppose, that one, it's absolutely, starting point is have those separate accounts, because if people aren't paying, you're not then outlaying the money on their behalf. But again, the BMS is a contract. It says you must contribute X, Y, and Z. If people aren't contributing X, Y, and Z, that's what courts are for. And it's sort of an early warning system to make sure that people know sooner rather than later that they're not, that others aren't contributing the way they should be. One of the other interesting things for the BMS in terms of the plaintiff in any proceeding is not the BMG, because the BMG itself is almost sort of a legal fiction. It's the representative of a partnership, for want of a better phrase, of all of those lots. So if we've got 6 lots that are party to a BMS and 5 are doing the right thing and 1 isn't, the other 5 are more than likely going to be the plaintiffs in any proceeding, as opposed to the body corporate, which would be suing a lot of unpaid levies. So those sort of nuances come into it.
Our BMS hasn't been reviewed in over a decade, and we suspect some of the operational arrangements are outdated or unfair. What is the process for amending a BMS, and do all parties have to agree? Is there any ability to change clauses that have become unworkable over time?
I think the starting point for me for that one would be, as Dylan's pointed out, identifying what the issues are, what the real solutions are, engaging with the counterparties in terms of this isn't working the way it should be, or the developer intended to be, or in a fair manner, and see where you get to from there.
If a commercial lot owner has changed ownership and the strata manager hasn't followed up on reimbursement of shared expenses, is it still possible to recoup somehow?
Oh, good question. I'd say yes, because I think the shared expense probably rests with the lot as opposed to the individual person that might be the owner of it at the time. And then you're back to, occasionally we've done sometimes people will come to us and ask us to do a due diligence on the purchase of a volumetric lot. And one of those things is always, where's the books and records? What do the accounts look like? Are there any arrears? Because ideally, unpaid BMS expenses should be an adjustment at settlement, like rates or land tax or water levies would be. So ideally, that was dealt with at settlement. But if people haven't done what they should do from a due diligence perspective, I don't think it absolves at first glance the lot from having to pay the occupier of the lot from those costs. What do you reckon, Dylan? Because the BMS is registered against the title, yeah?
Correct. So it's registered against the title, so it's not going to extinguish a legal right. Because if that was the case, that'd just be a free kick. Like if you could rack up, in theory, substantial costs and then sell off and say, oh, we've sold, it's all absolved. It just wouldn't
Transfer it
work.
to a related entity, cop the stamp duty, walk away from the debt. Yeah, that wouldn't really be fair, would it?
It wouldn't fit the general norm or the mechanism. It's on title. That's for a reason. I'd be very surprised if you were prevented from enforcing that, to be honest.
Okay.
And actually looking at a question there, BMS changes where body corporate make changes affect other body corporates from the structure. Like one of the things we're seeing at the moment is insurance. So tattoo shops were the no-go zone a couple of years ago. Now it's vape shops, smoking shops. They're just almost uninsurable. So making sure that people are aware of so you go to a BCCM perspective, if someone uses their shop in a way or uses their lot in a way that increases the premium, then that premium can be recovered from that particular lot owner. You're back to, in a BMS context, making sure, well, does the BMS deal with this? And if the BMS doesn't deal with this, then to me, if you're talking about what's just and equitable, then I'd be sitting there saying, well, if someone's going to use their lot in a way that makes the building uninsurable or completely blows the premium out of the water, they should be bearing the cost of that because it's their specific choice that has exposed everyone else to that increased expense. Does the BMS say that though? There's your question.
We always like to go back to our presenters at this point and ask if you've got any final words you'd like to leave us with before we end the session. So Frank, I might start with you.
There's hope, I suppose, is what I'd say in relation to changing things that are fundamentally unfair, because that has not been the case up until just now. But I think, as Dylan sort of pointed out, it's not just he's not a magic wand. We're going to fix it, make everything to be what you want it to be. There's got to be a basis for it. But that is better than what it was. You know what you've signed up to. And if you think it's unfair, you've actually now got the opportunity to do something about it, would be my takeaways.
Okay, thank you. And Dylan?
Look, I think I'll sort of just pivot off Frank there a little bit in terms of communication understanding. I think is still key. You've got a new toy to play with, that's great. But understanding what you are bound by is the key principle that will make any solicitor just jump up and down with happiness. My client comes to me with a problem, except that, but they come in and say, look, these are the documents I've found, these are the documents that are applicable, this is what we've been doing. Like that will save so much time and hassle. And, we're merchants of time. So if I'm not spending those hours, you're not paying for them. But you'll find as well, just naturally, you'll be more committed to it. You'll have a degree of confidence as well. It's not, we're not sure what we're doing. It's okay to be unsure, but just not blindly applying things is literally the biggest pitfall you can avoid. Knowing your documents and getting the help you need is key, especially if you've got a document that you're not happy with, it's old, it's not fair, and you want to consider this. Do your research. Have a bit of a look at it. It'll absolve you of so much stress straight off the bat. It's not funny.
I think this session has been a really great place to start for people as well if they're not sure where to begin. This gives them a bit of a background to begin and then they can go from there. And also I thought one of the other points you made during your part of the presentation was the fact that you do have to go back and live with these people at the end of the day. So you're living side by side, part of a community. What is the impact on the community by making a decision to make a change like that?
Absolutely. Like the financial, everyone always goes to financial with litigation. Oh, it's expensive. No one fully appreciates the mental toll. I'm a robot. I'm a litigator. I do this every day. Normal people shouldn't be in court. It's not normal. You don't handle it particularly well. There is an emotional toll that you finish whatever you do for work, you go home and you need to spend 2 or 3 hours with me on the phone where I ask you some very invasive questions and you pay me for the privilege. And if that goes on for 12, 24 months, it's not a fun time. You're not going home, there's no relaxation. You're going to your second job, which is you're a litigant now. And you've also got to deal with the snarls of the person you've wronged, who won't forget it. So there is serious consideration for any sort of litigation that comes from the emotional side. But it is a toll. It is. And if you do some quick maths in terms of the time you spend on it, that's time you're not making money. That's time you're not spending with your family. That's time you're paying me. So it's a double-edged blade. And, you're in a community.